code of any law from time being enforced, it's minimum 7 years or more. Your Lordship, as far as heinous offences are concerned, these are the only those offences which provide minimum sentence of 7 years and above. This leaves out the host which provide a minimum sentence of 7 years. Your Lordship, the fourth category of the offense, sir, sorry. Sir, the fourth category of the offences are those in the minimum less than 7 years, there is no minimum punishment is prescribed, but the maximum sentence. So the offences include under 304, 121A has no provision. Sir, as per the section 15 of Juvenile Act, which deals with the determination whether a juvenile should be treated as an adult based on the severity of the offense. In the present case, Ramesh was the juvenile at the time of accident. He was above the 16, below the 18. But sir, this age bracket is considered to be closer to adulthood. Ramesh should be held accountable for his action. Sir, in the case of Ashok Kumar versus State of Haryana, Supreme Court held that the heinousness of the crime should be a determining factor in deciding whether the juvenile should be treated as an adult or not. Sir, Ramesh as an adult is necessary to deter others' potential and uphold the principle of accountability for the seriousness of offense. A lenient approach toward the juvenile offender in such case sent to the wrong message to the society. The Juvenile Act 2000 was very lenient when it comes to holding to the child. But after the Nirbhaya rape case, 2012, it became the reason for the parliament to enact the Juvenile Act 2015 is a rush and response of growing tension and scrutiny. The act is not lenient, but rather deterrent. Your Lord, sir, the principal deterrence in the criminal law and cited case where the court have emphasized the importance of holding individual accountability for the serious offenses. As per the maxim of Salus Populi Supreme Lex, the welfare of the people is supreme. In this case, involving the heinous offense, it is important to protect the society and ensure the welfare. Therefore, this is the one of the main reasons to try Ramesh as an adult. In the present case, Ramesh should be tried as an adult as culpable homicide is a grave crime, despite the fact that 304 of IPC does not prescribe minimum sentence. The absence of minimum sentence could be seen as an opportunity to exercise the discretion and determine the appropriate punishment, including the treatment Ramesh as an adult. As per section 83 of IPC, where child with the age group 7 to 12 is also held liable in the several cases where he was having the knowledge that what could be the consequences of his case. And in the present case, Ramesh age group is 16 to 18, which is far better than or far mature than 7 to 12 age group. Therefore, he must be, the consequences of the case must be considered and he should held liable. Now, for the further proceeding, I would like to call my co-counsel, sir.
So, counsel seeks permission for the further proceeding. Much obliged, sir. The parents parentry, which means parent of the nation. There is a role of state as protector and guardian for the welfare and rights of children. Also, the state has a duty to ensure justice of victims even when the accused is a juvenile. Sir, we have to focus that even when the accused is a juvenile. And the doctrine supports treating Ramesh as an adult in cases of heinous offenses. The doctrine of legislative silence, the absence of a specific definition of a heinous offense in the Juvenile Justice Act implies that it's left to the court's discretion to determine based on the nature of the crime and consequences. Doctrine of social justice. The principle of social justice and not classifying serious offenses as heinous when committed by juveniles, could lead to an unjust situation where the gravity of the offense is not adequately recognized. The nation should not be applied to all the cases. There should be some grave offenses, especially when the crime is such a grave offense in nature that heinous classification is warranted. This is high time to exercise Article 141, which provides a unique power to the Supreme Court to do complete justice between the parties, where at times the law of statute may not provide a remedy. In those situations, the court can extend itself to put an end to a dispute in a manner that would fit the facts of the case. The ideal example of the exercise of Article 142 is the Ram Janmabhoomi case, where the five judges bench of apex court allowed the construction of a temple on the disputed land. Court and unless as to discovery, the Supreme Court in the exercise its jurisdiction may pass such decree or such order as is necessary for doing complete justice in any cause and matter pending before it. And any decree so passed or order so made shall be enforced throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament and until provisions in the behalf is so made. In such manner as the President may order prescribed. Subjects to provisions made in the behalf of Parliament and the Supreme Court shall, as respect the whole of the territory of India, have all the every power make any order for the purpose of securing the attendance of any person, the discovery and production of any document, or the investigation or punishment of any concern. In this case, Supreme Court reduced the time period under Section 13B of Hindu Marriage Act as to ensure that there is no failure to end of justice. This means the Supreme Court can pass any order even if it is not explicitly provided for in the existing law to ensure that justice is done in a particular case. Hence, in the present case, also under discretionary power given in Article 142 of Indian Constitution, remove the word minimum from the definition of heinous offense given under Section 2, Clause 33 of Juvenile Justice Care and Protection Act 2015 in order to ensure that there is no failure of end of justice. So there were many cases. Suppose a case that Ramesh should be held liable for the offense. Ajay Kumar versus State of Haryana. This case discussed the circumstances in which a juvenile can be tried as an adult based on the nature and seriousness of the offense. So we have to focus on the nature and seriousness of the offense that should be grave, and the minor can also be treated as an adult. And the second case is Ram Raj versus State of Chandigarh, 2006. This case delved into issues of trying a juvenile as an adult in cases involving grave crimes and criteria used for making such a determination. The case Raju versus State examined whether a minor accused of a senior offense should be treated as an adult, taking into account and specific circumstances of the case. The second case is Pratap Singh versus State of Punjab. The case in heinous offences and treatment and legal proceeding. The last case, Suresh versus State of Tamil Nadu, this case explored the factors and consideration in determining whether a juvenile offender should be treated as an adult, specifically in cases of crimes of severe consequences. Sections which deal with based on the severity of offense. In deciding whether a juvenile should be tried as an adult, the court emphasizes that the severity of the offense and its impact on society should be considered. In the further case, Rajendra Prasad versus State of Assam, 2008, the Supreme Court in this case, they affirmed that the nature of the offences is significant criteria in deciding whether a juvenile should be treated as an adult. The court pointed out that heinous and grave crimes should be dealt with differently. In the light of the above cases, the offense committed by Ramesh resulting in the death of in Suresh was serious and grave crime. There is loss of life which impact on the victim's family and society as whole negatively. It must be considered as heinous offense. So counsel seeks permission for the prayer. Much obliged, sir. Wherefore, in the light of accused raised authority cited the argument advanced, it is prayed that this honorable court may graciously please to declare and adjure that defendant must be held liable, uphold the conviction of the Juvenile Justice Board, and set aside the judgment of High Court. Pass any such order as the honorable court may deem fit in the interest of justice, all of which is most humbly and respectfully submitted, or pass any order, writ, or direction as the Honorable Supreme Court deems fit, or for its plaintiff shall pay bound prey. Yes.
Yes.
You have to show him out. Or
Yes.
intention of the knowledge. Otherwise, this case will come under the chapter of section 8 4A, and for this the maximum sentence is 2 years.
Yes, sir.
You have to show in your petition that आपको दूसरा भी ये बता
Yes, sir. Yes, sir.
आपको
Sure.
दिखाना है कि circumstances extreme various circumstances illegal so आपको याद होगा अभी बेरोक में जैसे इसका 304 पर परिधि में है सिंपल अगर एक्सीडेंट नहीं होगा तो आपका 304 ए परिधि
Yes.
तो आपको अपने पेशेंट आगे से लगा इस चीज दिखानी है कि मौखिक क्या था उसका लीडरशिप क्या थी and whether he had any knowledge by his act and great accident may happen कि उनको तीनों को दिखाना पड़ेगा that's okay.
Okay, sir. Thank you, sir.
Secondly, जब आप argument पेश करें और argument should be presented in such a way that you are addressing the point. You are just having a plain reading of your claim, not giving your arguments, way of presentation.
Yes. Thank you.
Secondly, जब आप value of punishment की बात करें, सरकारी जेल से सरकार एडमिशन की बात करें, और you have to prove in your petition that what was that very intention and knowledge to the person that I caused this injury to the victim, and so that we had. जानते हो आपको उसमें आपके एप्लीकेशन में ये बात कर रहा है कि आप सिर्फ डिमांड कर रहे हैं कि किया जाए और इसमें सिंगुलर कंटीन्यूअस प्लान करना you have not placed any evidence in your petition. As I have read it, that why the maximum punishment here and how he had a knowledge of it.
Yes,
I
sir.
have all this in very detail.
Yes, sir. Thank you, sir.
Application proof करना है तो तीन चीज है आपके सामने है कितना बैलेंस रखना है समझ होती है स्टोरी में है
Yes, sir.
तो आप ये प्रूव करिए ऐसी एविडेंस होनी चाहिए आपके उस पर अगर कुछ बात की नॉलेज नहीं कि जिसको बताऊं से कुछ जब उसकी इंटेंशन की समान आपकी कहीं भी इसमें नहीं है कि ऐसी एविडेंस है आप उसको मानना चाहते हैं तो सिर्फ सिंपल है कि फ्लैक्स पे दिया और जो चार्ट लगा
No, yes, sir. Sir, it was already mentioned is whether we have whether 304 is coming within the 2 clause 33. So we, sir, actually I have that point, sir. We have saved it for the rebuttal. Sir, I didn't mention it. I have just. Sorry, sir, we didn't mention it. We just save it for the rebuttal. No, sir. But, sir. Sir.
Anything what you are in the court without the record is meaningless.
Okay, sir. We will learn it from for the future, sir.
The record or the thing should bring to the record. That should be bring to the record. Then you are on that. And
Okay,
then you
sir.
elaborate that fact and fact circumstances and that evidence in your words. Only clearly saying that to be punished under section 304 or 302 and he should be given a punishment, technical punishment, and punishment. That is not possible. Then the petitioner should be that a juvenile caused an offense and he should be punished in a heinous crime.
The respondent seeks permission of the Honorable Court to address the bench as the May it please the court, my team court is PCDOC, counsel for the respondent in the present
This is Ramesh. Sir, the respondent will specifically deal with two issues. Issue number one, by me and my co. Sir, Ramesh is he caused a motor vehicle accident wherein Suresh died. At the time of the accident, Ramesh was above 16 years but below 18 years of age. Ramesh is charged with an offense punishable under Section 304 of the Indian Penal Code. No minimum sentence has been prescribed for the offense punishable under Section 304 IPC. Tried as an adult. An appeal was filed against this order and the appeal was dismissed. Therefore, Ramesh, therefore his mother that in reference to support which are relevant to number 9 in Project Officer District Rural Development Agency versus Ashraf. Court held that Section 160 accident lay tribunal for the purpose of a 14-year-old son that the insurance company couldn't exonerate itself from liability because there were no bills. Tribunal. From the argument advanced, authorities cited case laws. Argument
बिल्कुल default upon Rakesh Kumar Arora. The Supreme Court, however,
first this case go to in tribunal, then it come to in high court, then it come to in Supreme Court.
that the insurance company was not liable by the
Applies your This is council number